The Honourable Chris Finlayson.
It's a fascinating contribution from Mr Prosser. It was more pitiful than his usual contributions because in the space of less than 10 minutes we heard that this involved selling our souls, corruption, a new low, bribery, blackmail. It seems rotten to the core. It seems that rather than reading the report of the Auditor-General, he's opened Roget's thesaurus to find the most colourful words that he can before he gave us that rather sad and pitiful effort. And frankly, Mr Shaw was just as bad because in the space of a few minutes, we didn't get the full speech time from him. We heard it was intolerable, a litany of incompetence, rogue behaviour, dodgy behaviour, not transparent. Well, let me say to honourable members that if there is an urgent debate in this House, then I suggest it's important to read the document and have an understanding of the transaction and have an understanding of the findings, not dive for a dictionary or a Roget's thesaurus. Come up with the most colourful phrases you can and cut to the chase and have a cold, hard, analytical analysis of what exactly went on. Because throughout this process, we've had exactly the kind of florid rubbish that typified Mr Prosser's speech and also Mr Shaw's speech, rather than focusing on the facts.
Order.
And I know focusing on the facts is something New Zealand First is particularly bad at, given their extraordinary performance in question time yesterday, but that is precisely what I want to do. And I want to say something first about the process, because there have been a number of complaints from Mr Parker and others that this report has taken too long to get out and people haven't been cooperating and that lawyers have got involved. The process that was followed by the Auditor-General in this matter was perfectly standard. It's been adopted whenever there was an inquiry. That those who could be the subject of criticism have the draft report given to them and they have an opportunity to make a comment for natural justice reasons. And so all that sort of work has taken a considerable amount of time, and now the report has come out. And the critical thing about the report is that and please, Mr Prosser, I suggest to him that he listen, there is no evidence of bribery, corruption, or facilitation payments. The report finds that all public money was spent within necessary financial approvals. That is the issue that the Auditor-General was asked to reflect on and report on, and that is what the Auditor-General, for the benefit of the big mouth from West Auckland, that is exactly what the Auditor-General, I'm sorry, it wasn't him, it was the fellow from Tauranga. That's the point that has been established beyond doubt by the Auditor-General. There is no evidence of bribery, there is no evidence of corruption or facilitation payments. What is also clear, Mr Speaker, is that the national government in 2008 inherited a problem that carried with it major diplomatic, economic and legal risk. And in his contribution this afternoon, Mr McCulley has spent some time addressing the diplomatic and the economic risk. What I'd like to do is briefly touch on the legal risk, because the legal risk is pretty clear for anyone to see. What if, for example, a proceeding was commenced in the Saudi Arabian courts against the New Zealand government? Would we have the benefit of sovereign immunity? What would the cause of action be? Would it be determined by Saudi Arabian law or New Zealand law? These are all the sorts of questions that a reasonable person, when analysing legal risk, would take into account when determining whether or not a matter should be settled. I can recall many years ago, as a litigator, being involved in a case where a New Zealand company was sued in Texas in Harris County District Court. No one paid too much attention to it till they realised that the law that would govern the particular cause of action, which was breach of confidence, would be Texas law, and that it would be heard before a jury presided over by a judge who'd been elected in the Republican landslide and was a probate lawyer. And so all those factors were brought to mind when determining what exactly the legal risk was, and even though the course of action was flaky, a decision was made that because of the legal risk of litigating in Texas in a difficult situation, there needed to be a settlement. And that kind of thing happens all the time when one is dealing with litigation in foreign parts. And the member interrupts, well, would that apply in China? Well, of course it would. Of course, you'd need to assess whether or not what would happen if you were litigating in China. These sorts of things happen all the time. There needs to be a mature assessment of legal risk. And that is exactly what has happened. And when one looked at the legal risk, which I, as a litigator, thought was blindingly obvious, and one also looks at the issues of diplomatic and economic risk, then one is led to the need to sort this matter out as quickly as possible. And linked with legal risk, if the case, for example, was held up in the Saudi Arabian courts for a number of years, that would have of itself infected our relationship with Saudi Arabia and caused immense economic harm of its own. I know that Mr. Prosser doesn't like the facts because he prefers to stand up and give a B-grade theatrical address relying on words like corruption and bribery, but at the end of the day, they're serious allegations, and he's protected by absolute privilege in this place. But you've got to come up with, one's own credibility, a few facts, and Mr. Prosser don't necessarily go hand in hand. Vague, immature waffle and Mr. Prosser go hand in hand. So that's the analysis of the legal risk. That's why there needed to be a solution to this matter, one that incorporated addressing the threefold problems of a diplomatic risk, a legal risk and an economic risk, as a result of which Mr. McCulley, and I believe Mr. McCulley quite properly, said this matter needs to be sorted out and reached a conclusion. Now, Mr. McCulley has stood up in this House this afternoon and acknowledged that maybe the process wasn't A-grade, and he took that on the chin, as one would expect him to do. And there are matters that are raised in the Auditor-General's report that all ministers need to reflect on, to dot the I's and cross the T's. Fair enough. But I come back, Mr. Speaker, to the core issue here. After all the months, both in this House and in press releases and outside this place, of allegations of bribery and a litany of corruption, all that sort of thing, what do we find from the Auditor-General? There was no evidence of bribery, corruption, or facilitation payments. At the end of the day, after all the purple prose, after all the hyperbole, the facts don't support what the opposition have been saying for a year. And quite frankly, Mr. Speaker, at the end of the day, this government in 2008 inherited a mess. It needed to address the various risks. It addressed the various risks. Maybe in terms of process, things could have been done better, but there was no finding of bribery or corruption. So my suggestion to Mr. Prosser is it's very important to look at the facts when determining this matter. It helps if in future, if we're debating a report, he's actually skimmed over it or read the summary or had the summary read to him, because these are important issues and one is dealing with the integrity. I'm sorry to pick on Mr. Prosser, but it was a pretty lousy contribution. And at the end of the day, what Mr. McCulley did in terms of process could have been better. In terms of substance, needed to address a very tricky issue, and he did so. And quite frankly, I think members who blandly and eagerly toss around phrases like bribery and corruption owe Mr. McCulley an apology.
Mr. Speaker,